Good day to everyone at this public hearing of the Vetting Commission established under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. This hearing is being conducted under the Commission's Rules of Organization and Functioning as part of the evaluation process. The subject of today's hearing is Sofia Aramă, a candidate for the position of member of the Disciplinary Board of the Superior Council of Magistracy. The evaluation of Judge Aramă was carried out pursuant to Law Number 26 regarding certain measures for the selection of candidates for the position of members in the self-administration bodies of judges and prosecutors. Judge Aramă has been the vice president of the Cimișlia Court since December 2019. She first became a judge on that court in 2014. Judge Aramă, welcome. I'm joined by...
Bine v-am găsit.
Good to see you.
I'm joined by four other commission members. To my right is member Lilian Ansu. To my left is Vice Chair Andre Bevel. And then other commission members Lavle Perling and Yuri Gatskin. The commission is also assisted by members of its secretariat, and you may see also in the room some members of the public or media. The photographer will take photographs just briefly at the start of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Only one person should speak at a time. Proceedings are being recorded. The recordings of the Commission's public hearings generally will be available online at the Commission's website at www.vettingmd.eu within 3 days after the hearing. I will start by briefly reviewing the evaluation process for Judge Aramă. The Commission initiated its evaluation on the 15th of February 2024 by notifying the judge by email and asking her to complete and return an ethics questionnaire and the financial declarations required by Law Number 26. Judge Aramă returned the completed declarations and questionnaire on the 17th of February. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspector of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for relevance and reliability. On April 16th of this year, the Commission asks Judge Aramă to provide additional information by April 25th to clarify certain matters. She provided answers and documents over the course of April 20th through April 23rd. On May 10th, the Commission asked Judge Aramă to provide some additional data and information by the 19th of May. She provided answers and documents on May 15th. On May 20th, the Commission asked Judge Aramă to provide some additional data and information by May 26th. She provided answers and documentation 1 day earlier on May 25th. On the 31st of May 2024, we notified Judge Aramă that the Commission, in its investigation, had identified some areas of doubt about her compliance with the ethical and financial criteria, and we invited her to attend today's hearing. On May 31st, Judge Aramă submitted by email a request to conduct the hearing in closed session. The Commission denied this request on June 4th, 2024, in a reasoned decision. Judge Aramă, do you wish to make any corrections or additions to the answers you've provided to the Commission's request for information so far?
Just if the Commission will allow me, in the answers I will develop during this hearing, I might be able to supplement the information that I said is incomplete or bring some clarity on the areas of doubt that were identified.
Well, we will ask some questions related to the notice of hearing, but I just want to make sure that if there's anything at this point that you feel like you need to correct or make additions to in terms of what you've already provided, let us know.
Yes, I'd like to add that starting from 2018, my father, Rama Vladimir, is the beneficiary of a pension for age from Italian Republic, and this was omitted. I omitted this fact to be communicated to the Commission. I believe this is an important aspect related to the calculations that were raised during my common stay with my parents starting from 2013 till 2022, part of this year, last year. And another aspect refers to the notification and the areas of doubts from the Commission. Well, as I perceived it, I didn't quite understand if the declaration was appreciated in terms of the purchase of the cars. Well, I support that this declaration needs to be retained. Another addition to the information presented by the administrator of insolvency, the authority of insolvency, they identified or indicated that the amounts which they indicated in some document or a letter. So Steel Construct has paid the lawyer's cabinet, but I want to attract your attention that this was a contract concluded for service provision with that respective company for a non-determined period, and the amount in the contract was to be 20,000 lei per month. Why was this indicated, the information by the insolvency administrator? I could not explain this. As I said in the materials and in the answers to the Commission, everything related to the activity of the lawyer's office was destroyed once I became a judge. And believe me, I never thought to have another position except for that of judge. If I would foresee such situation, I would have gathered all the accounting information. The lawyer's office had an accountant responsible for all the accounting part. She prepared all the documents, all the aspects to be declared to the tax office, and also elements referred to the income tax. And actually, I did not check the activity of that accountant. Only now I understand that there are some things I did not control at that time. The activity of the accountant in relation to the activity of the lawyer's office. And referring to the information related to the car model Mazda 3, registration number IHO 926, I think. What the Commission identified as information published on the website 3W999 related to the sales announcement for this apartment. I've looked for this car. Sorry, I've looked for these images, and I really understood that the registration number was of that car that, following an accident, was destroyed in a rate of 90%. But the pictures or images on that site of the inside of the car are not the same. The inside of the car was black, but it has elements of red inside the interior of the car, which means that the person who bought the destroyed car has rebuilt it, reconstructed it essentially. I have tried to look for some pictures, some family pictures, to have the image of the interior of the car as long as I've had it in my ownership, but I did not find some pictures for that. These are some aspects that I could mention. in terms of additions.
All right, well, we'll come back with some follow-up questions on topics that you've mentioned, such as the cars. Let me, before though, ask, are the answers to the ethics questionnaire that you returned on February 17th, 2024, are those answers still accurate as of today?
Yes, they are valid, but to add to this questionnaire, I've omitted to indicate a civil case. I was defendant for receiving a debt, and I want to mention some complaints from a petitioner, family Negorei 1 and Nadezhda, who actually filed several complaints to the judiciary inspection under SCM and the General Prosecutor's Office in terms of having examined the judge's behavior to hold them criminally liable. And these complaints or cases resulted in rejections of the complaints, but I've omitted to indicate them in the ethics questionnaire. Maybe I understood somehow different the request from the Commission. So I've indicated now what I recalled, and I think there's another civil case when a beneficiary of the lawyer's office filed a case in the court, an application in court invoking some amounts related to illicit enrichment, which was also rejected, this application.
So
these are the aspects.
Those were all items that were omitted from your questionnaire that you're now identifying, just so I understand you correctly.
Well,
after I looked through the materials that the Commission presented to me, at that moment I actually recalled about these decisions, court rulings, which were collected or are part of the materials in the files with the Ethics Commission. So when I filled in the questionnaire, I indicated what I remembered. And in all my answers, I advocated for the possibility to have the information as fully presented as possible, but I did not have the possibility to collect all the possible information to present it to the Commission, with information related to the questions in the rounds of questions.
Judge, the Commission will now ask you some additional follow-up questions. As I said, we'll try to keep our questions short and to the point, and we ask that your answers be short and responsive to the question as well. Commission Member Yuri Gatskin will begin the questions.
Good afternoon, Madam Sofia Aramă. According to the notice for hearing and materials presented by the Commission, I will come to you with several questions related to the differences between incomes and expenses for several years, and some aspects related to the infringement of the regime of declaring the personal address. First question will target the year 2011, when the Commission found a difference between your incomes and expenses amounting to about 363,000 lei, the major discrepancy in your incomes. And the core for this would be the purchase of two cars, one Suzuki model amounting to 190,000 and the other 174,000. So in the first round of questions, you indicated that these cars were bought by the founder of the company Steel Construct that you invoked. For the provision of the legal services, which was indicated as an advance payment or as a debt for providing the services during the next years. You also mentioned that the contract And in that contract, there were provided some conditions for repaying these amounts. We did not see this contract. The Commission did not have it in front of them. You mentioned that it was destroyed in 2015. Well, my first question to you is that whether this contract was signed by Steel Construct and your lawyer's office, or you as a natural person. Well, I will explain the following. The legal assistance contract was signed between the lawyer's office, Sofia Aramă, and the building company, Steel Construct, and as representative of this company were the administrator and founder of this company, Mr. Anatoly. So in that contract, we've indicated under the conditions, conditions of the contract, and in the first round of questions, I indicated the activities provided by that contract. I have included these activities from what I recalled from my activity, because legal consulting was not based only on representing in court these companies, but also it included representing the legal activity of the company in terms of the activity the company had. So in 2011, this company had several projects. Most of the activity was focused on creating buildings in Chișinău, and also constructing a commercial space type supermarket in Stăuceni region, Stăuceni commune, and restaurant and a nightclub. Well, my activity as a lawyer involved myself being in charge of this project, starting from the initiation till giving them for having them functioning. The contract included just general provisions, and the communication was mostly between me and the administrator were verbal. The contract mentioned more about the payment conditions, but in that contract there was not exactly indicated the purchase of a car or repurchasing it in that respective sense. But was there indicated an advance payment in the first year of activity? No. This offer from the administrator was purely personal. At that moment, it was the period when I got employed or somehow became the lawyer of this company, because there were several specialists. It was a specialist in marketing, another specialist in tourism and hotel business, and the third one focused on sales activities. Well, my activities included, in terms of the internal activities of this company, Mr. Anatoly, at that moment, for all the 4 young specialists, he bought a car, and the conditions for repaying this car depended on the conditions of the volume of work provided by us. Even though every year we had an analysis or a summary of our activities. Well, actually, this was mostly a verbal agreement for the repayment of the service. Well, the Commission's question mostly refers to the way those cars were paid and from what sources, because according to the data from DAC Auto, as you've seen in the notice, in the invoices, you are indicated as the person who paid. In the invoices, it is indicated that you've paid cash at the office, at the headquarters of the company. So you went personally, yes? Yes, I was present together with Mr. Iașciuc. He had the money, I signed. Do you know what sources the administrator has used to pay the cars? Well, let me tell you, I've analyzed a lot the subject, so I might anticipate some questions. I did not ask him at that moment about his availability to pay for these cars. Was he paying as a founder or as a natural person? After I somehow integrated in this exercise and I had to ask questions, I discussed with him about this topic to be able to clarify some aspects, because I had to identify and to present some documents to identify the insolvency administrator in order to come with some supporting documents in that sense. So he let me know that these were his personal money he used to pay for the cars. Money was in cash that he had available to pay for the cars. But let's understand, did you have any opportunity to see some supporting document that this money was withdrawn from the activity of the company? I don't know from where Mr. Yashchuk had gotten this money. I cannot tell you. And honestly, I did not have a doubt at that moment about this issue. So the legal relations between your lawyer's office and the company included a fee of 20,000 lei, and Mr. Administrator bought for you these cars, paying in cash, but you do not know if this money was withdrawn from the company's account. I do not know, and I would not risk to give you an answer because I am not convinced about my answer. Because in the first round of questions, you answered that it was from the accounts, from the company still construct. Well, I deduced this from the question. When the Commission sent to me the round of questions, I deduced the answer. But later on, when discussing with him, I understood the meaning of that activity. Well, actually, my activity at that company and his activity at that company included a lot. He had different sites in different regions of Chișinău municipality, and the sites related to recreational activities like the nightclub, restaurant, and the hotel were in Stăuceni. So myself, as a specialist of the company, I had very often to travel for service in those regions, in Stăuceni basically, where we had a different situation. We had even an accident at work when a worker fell from the fourth floor. So we basically had to be there in order to solve this issue. I think it's understandable, this element. Yes, we understand that you have provided some services, you were engaged in a lot of activities of this company, but explain us, please. During the next period, after these advance payments were paid or these cars were paid for, how the administrator was repaying or covering this debt? You were covering this debt? Did you have some verbal agreement or some documents? No documents. We came back to this discussion the day when I informed the administrator of the company that I already was accepted in a competition, in a contest for the position of judge, and I requested an order to be issued in my relation to be suspended from the activity, from the position of lawyer. So I was suspended from the activity, from my positions, since I applied for this position of judge, and everything we discussed was just verbally. We did not have any handing over documents. Okay, thank you. In this period, when you purchased the first car, the car from the company, you had some other payments except for that monthly payment? No. So you've repaid that the price for the car from the salary you had, the fee you had as a lawyer in the company. If generally, yes, maybe there were some payments that were delayed for the lawyer's office, like related to obligation of the lawyers or payments related to the pension fund. But I had no other sources. If I had access to to my accounting activity, to my accounting documents, then in that case I might have been able to provide you more information. I want to clarify on this amount of the car. This first car was purchased on 9th of June 2011 when it was my birthday. So this day was related to the purchase of the car and with my activity because I had a very short term activity in that company. I was not for a long term in that company at that moment. So this car in the fall 2011 was damaged being in a parking lot in Chișinău municipality, where when I was to go to the countryside, I hit a dog, and the car was damaged essentially. And this car was bought by Ion Sandu because I went with him to the Suzuki company, to the car service of this company, to have an assessment of the damages in order for myself to know what would be the exact amount for the repair works, in order to understand if there is not an insurance case. And when he assessed these cars, he made me an offer. So I buy your cars, and you pay the difference of prices between this old car and the new car, and you live with the new car from our center. Well, I accepted this offer, and the amount, as it was indicated by the Commission, 198,000 and 170,000 and something. So for the second car, part of the amount is from the first car, because the money remained immediately to the company. The transactions were made immediately, and again, the difference in the amount between these two cars. When I went, I had with me Mr. Yarchuk. So we went together with him and we conducted this transaction. What was the difference? So from what I recall, it was a difference of 4,000 euro. Approximately. And this transaction, Mr. Sandu could confirm it or give you more clear details about the amounts of money that were operated at that moment. At that time, he was the director of Suzuki Center. That's why I requested to the Commission to hear him, if the Commission considered this necessary for this fact, because other documents I could not provide. If I knew, I would have kept them, but I did not consider this as a necessary moment. So, to conclude, you had no other fees or payments for your legal services, only you had this car for this from this payment, your legal services were deducted. Do you think that these were legal services that had to be declared to the tax office? Currently, yes, I could tell you, yes, the first amount had to be declared, but I have omitted this. So you failed to declare this amount for the lawyer's office as an amount, as an income. No, I did not declare this as a lawyer's office and as a natural person. And next question. Did you have some other sources of income? Other sources of income I did have during the year. So, to clarify, well, you can look in the table and follow the table. For example, 2011, you started the year with some savings of 3,000 lei, a salary from the SCM. Some other source of income is the alimony for the child. So starting from 2020, after the divorce, he has to pay the alimony. He came in the country in 2010, and as a reason to come back to the country was a second divorce. So at that moment, we've discussed some issues about the situation that was created, and at that moment, I refused my title, the services of the bailiff, and we had a convention in that sense. So let me explain. It's a different source coming from the ex-husband, like an alimony, and from the grandmother. And this covers your consumption expenses. Yes. For the rest of the years when the Commission identified the difference between your incomes and expenses, could you indicate what will be the other sources of income and if you have some supporting documents in this regard?
So, to say that would confirm the agreement between you and your former husband to set a certain amount for the alimony. We did not set a certain amount. This was his decision. He had an apartment in Romania, in Brașov. This apartment was rented out, and the rent varied between 200 and 250 euros. And this money was offered for supporting the child. Initially, this was sent through the grandmother until 2014. Then the grandmother got sick and could not travel between Chișinău and Brașov anymore. She used to live in, or is living in Brașov, and she managed the situation with the lessees, and she would bring the money at least once in 2 months. She was here in Chișinău visiting us and bringing this money. This lasted until 2014, until the grandmother got sick and she could not come anymore. And throughout this period, sometimes he would make international transfers. It could be 100 or 200 euros. I really can't recall, and I did not make a total of the amounts, let's say, for 2011. We did not have an agreement for a certain deadline or amount, but we agreed that we would continue because he was not in the life of the child for 8 years. And there's another issue. When I needed money urgently, I would call him and he would send money to me. He works as a tour guide. He can be in Italy, Spain, Portugal, Ireland, so it depends on where he is. We agreed that how he could send the money. What was the approximate monthly amount for 2012, for example? For 2012, it was approximately 250 euros. So it was the price for renting out the apartment in Brașov. From what I know and from what I learned, this was 270 euros. According to the analysis of incomes and expenditures for 2012, you mentioned that we have a difference of 82,000 lei. Even if we were to calculate and add 2,500 or 300 euros, it would still not cover this whole difference of the amount that is for supporting the child. Regarding 2012, your lawyer's office, Sofia Aramă, declared losses minus 6,000 lei. So the rent for the apartment was often covered by my parents, because throughout the period when I was working in Chișinău, I received financial support from my parents, and this is still present nowadays. We have situations when my parents are helping us financially. And indeed, there was this condition for renting out the apartment, but I can tell you for sure, because as a lawyer, I really needed time to develop. And what was the contribution of your parents? My parents, after 2010 and until I started living again with them in Cimișlia, they would give us approximately 150 euros to me and other types of support, but I don't remember. Could you tell us why did you not present this information in the first rounds of questions? To be honest, I did not think that there could be doubts about this. And I could not have an estimate calculation to understand there are these incomes, these expenses, and to see what the difference would be. Regarding the other years for which the Commission identified the differences, do you have the same arguments, or do you think that there were also other sources of income? There are the same sources. So, since 2013 until 2022, I used to live with my parents. So, the support from my parents was essential because I did not have expenses for renting a place. I did not pay the utilities. I only had personal expenses and the ones related to the education of the child. So, otherwise, my parents covered fully the other expenses because we used to live together. So, we had joint sources of income, inclusively my sources of income, the salary and the alimony. And we always had a common budget. But my parents tried to give me the possibility to cover for the credits, for the leasing, because in Cimișlia the car was a need. The child was quite young, and we had additional educational activities for the child. And maybe the calculations of the Commission is correct based on the indexes from the NBS, but my situation was a bit peculiar, let's say. Now I will mention the aspects related to not declaring the funds related to the alimony. Throughout 2015, 16, 17, 18, 19, 23, you mentioned every time the income for alimony as 300 euros. According Law 133 and the instructions for filling out the asset and personal interest declaration, under incomes, we should have the total annual incomes. This is not the annual value. I acknowledge the fact that I did not fill in these declarations correctly. I take responsibility for this. And during this exercise, I understood this because I mentioned the alimony as 300 per month. And I didn't think that this could be interpreted otherwise than the notion of alimony for a minor. You cannot support a minor for 1 year for 300 euros. And the same for the father of the child or my current husband. According to the bank details or the bank information regarding the transfers from abroad from your ex-husbands, we did not see these systematic transfers for each month. You mentioned that they were sent through your relatives. Yes, part were sent through our friends through the regular buses or through the relatives of the husband. Sometimes his brother would come because he's also living in Ireland, and when they used to come here, they used to bring a substantial amount. So not declaring this amount, 300, 600 euro, would this be a significant error in your opinion? Yes, this is indeed an error, but I cannot classify it as significant because the notion of alimony for a minor, well, I admit that this is an error in the sense that I filled in the declaration in a wrong way. Also, the Commission identified that in your declaration for 2019, you did not indicate the incomes from the sale of the Mazda 3 car, the 10,000 lei. Yes, according to the sales purchase, the person that you gave the power of attorney to sold this for 10,000 lei. This means 508 euros. At the same time, according to the assessment report after the accident that you mentioned, when the car was destroyed for 90%, the remaining value of the car was approximately 44,000 lei. And this report was drafted on the 22nd of October 2018. Did you know about this? Yes. Yes, this was drafted at my request. Later, you drafted a power of attorney and you sold this to an individual. Yes, it was very damaged. The value was also 10,000 lei. Yes, 10,000 lei. I give this to a person who had a parking lot for spare parts. So I did not have a financial interest. Given the situation I was with this accident, I just wanted to have no other things to do with this. I could not afford to repair the car. I accepted the report from the insurance company. The person that caused the accident was 21 or 22 years old. They had a bad financial situation. We tried to discuss this, but I just gave up. So I just gave it as it was. But why did you accept the amount of 10,000 lei if the remaining value was approximately 44,000? I didn't pay attention to this, to the value after the accident, to be honest. So in this damage case from the insurance company, I just wanted, because indeed the car was damaged at 90%, so I wanted to have a full scrap of the car. But in the end, I accepted the decision of the insurance company, and I accepted the financial means offered by this company. And this money was used for the first leasing payment for the next car. According to the Public Services Agency, this was later sold on the 14th of March 2019, so in a few months. According to the photos presented by the agency, the car seems to have been repaired, to be in a good state. The technical inspection was carried out. This means that the car could have been used. It couldn't have been used. I mean in March 2019 when the car was sold. So since November until March, indeed it could have been repaired. The question is, did you contribute to the repair works for this car? No, I don't know anything about what happened to this car since it was sent to this parking lot. So you took this money from the insurance company and you did not use it for repairing the car. No, I don't know anything about the fate of this car. And based on the photos that I saw, the ones that they were on this www.999.md, the interior was different from the interior that I had. It might not be the same car. I don't know. These are just doubts, probabilities. The problem is with declaring these income sources from the sale of movable goods. What do you consider not declaring, the failure to declare these incomes is a violation of the legal regime? These 10,000 lei were not indicated in the declaration for sure. They were probably not in the cap for declaration that was foreseen in the law. What cap do you mean? There's a certain quantum. Law 133 does not mention this. I can't tell you. I probably omitted it or didn't take it into account when I filled in the declaration regarding the 10,000 lei. Because actually I had more losses than gains, and also from the point of view of my health state. And also regarding the legal regime for declaring the assets and the personal interests, I will refer to the real estate property that you are using since 2022. The Commission identified that you concluded a contract for services for internet and telecom since 2020 on that address in Cimișlia. Yes, the StarNet contract was signed in July 2020. It was not necessarily for that apartment because there was an offer from that company. They would say that so we had just moved to Cimișlia, and based on the situation, the fact that I had a child that was about to be born in that year, the father of the child was looking after this apartment because it belonged to a relative that had left to the U.S. Several years before. Before the child was born, the father didn't go too often to Cimișlia. In 2012, he left for good to Chișinău. So, based on this family situation, or more certainly the presence of the child, because we were not a family back then, he would stay over the weekend in this apartment. And there was no television or internet in that apartment. And when we discussed about the offer from this company in this city, we agreed that I would conclude the contract because for my parents' apartment, I also have the contract. So the offer was to have two places where we would use the internet and the telecom services. And we agreed that we'd conclude this agreement so that he had access. So you didn't use it all the time? No, but I used to pay for it because I was the beneficiary of the contract. Maybe when I didn't manage to do this, Mihai did. But we didn't live together so that we would declare this until 2020 when we decided to buy the apartment and to get married. And in that moment, we decided to live together. and this apartment was used free of charge by your husband. Yes, we are not paying rent, we just take care of this apartment and we are paying for the utilities. Thank you, I have no further questions.
Yes, Commission Member Perling.
Da, membru Comisiei Perling.
Thank you. I would like to go back to the Suzuki cars and please could you answer very shortly? You are a lawyer. Could you please explain us what kind of legal status the cars had? First of all, they were part of your salary. The second, they were just a tool to perform your business tasks. The third, it was gift, or the fourth, it was something else. It's important because the question is how it was taxed. So, and please, your answer.
Așa. Automobilul oferit a fost cu
The car that was offered to me
a fi utilizat în scop de
was meant to be used for my work, and I was about to pay for the amount depending on the services that I would offer. We did not have such an agreement saying that I would pay a certain amount each month to repay for that car. To be honest, I don't label it as a present or a gift because we used to work for this company throughout this period, and I had a lot of physical and intellectual work that exceeded the fees that I received from the company. Somehow, when we concluded our work relationships, this made the administrator not to ask for any payments. When I sold these cars and I bought another one in leasing, this was also with the agreement of this person.
Sorry, but what was your answer? What was the legal status of the cars? How you taxed?
Ce aveți în vedere cum erau taxate?
What do you mean by how they were taxed?
What was the legal status of the cars? As a lawyer, what would you like to say us?
În calitate de avocat vă explic.
As a lawyer, I will explain the movable. This is a movable good that was offered to the lawyer in order to be able to work for this company. The reimbursement of the course for the cars was agreed with the administrator of the company, and this was about to be done through the volume of work. Sometimes I would even take care of the family businesses or issues of the family. So I had to be available as soon as possible when there were urgent situations.
Doamna Aramă, bună ziua.
Hello, Madam Aramă. The questions about taxation and this unclarity are caused by the fact. Well, the question is, if these cars were used for work, and this was the purpose to facilitate your transportation for work from one point to another or to work, then why weren't these cars just bought by Steel Construct and offered to the employees based on a contract for liability? But they were given to you as owners. And based on the information we have, it does not show that they were related to your work responsibilities. So this is the question. What was the reason for the fact that they were bought, from what I understand, with cash by the administrator of the company and given to you as a property. This is why we are asking about taxation. Was this fiscalized? I understand the question since the first round. I think we should ask the person in cause. This was the decision of that person. I don't know whether I could have declined the offer. So when he offered to purchase such a car, so it was the decision of that person to have this on us as owners. Indeed, I did not have the possibility to purchase a car in that period. And based on my financial history, it is clear that I didn't have money, and I didn't have other activities or other sources of income. And I'm not that kind of person. And I take responsibility for the declarations that I am making now. I am a judge, and I understand now, I understand the consequences. I would not have come with false declarations in front of the Commission regarding the questions asked to me. I acknowledge the fact that there were errors when I filled out some statements, and it was my responsibility to fill them out correctly. But this is what happened. The alimony was declared in that way. In my opinion, the alimony is paid monthly, and this is why I declared it in such a way. This is why I requested for the Commission to hear the person, because this question should be asked to that person. It was his desire. This is how he worked with all specialists. I was not the only one benefiting from such an offer. There were also other employees that for whom such cars were bought by this person in the company. And indeed, we all work hard until 2014, when I decided to become a judge.
Yes,
Vă rog să concretizăm. Ați menționat că
Please mention, you said that the administrator did the same with other employees also. Yes, these were important persons in the development of the company. They would buy cars for the work that was done. Did the person buy Suzuki for everyone, or the persons decided on the brand and the model? No, it depended on the offers from the companies, and I'll give you an example. When we purchased the Suzuki in 2011, so this car was brought on the market for the first time back then, and the model that was existing in 2018, the company made us an offer for such model. A colleague bought a Ford Escort, for example, and the marketing expert, Madame Mișanu, was purchased, so a Ford car was purchased for her. It was also a small one based on the offers from the companies. Actually, the administrator would choose the company, the model, he would decide on the amount, on the technical aspects.
Și raportul dumneavoastră cu compania respectivă,
And
raportul
your
de muncă,
relationship,
am în
work
vedere,
relationship
se
with that
rezuma la
company
mandatul
was
de avocat.
limited
Nu ați fost
to
angajat,
the
nu ați avut contract
mandate
de
as a
muncă,
lawyer. You did
doar
not
în baza
have
mandatului
a work
avocațial.
agreement. You were
În
just
aceste
offering
condiții, dumneavoastră spuneți că ați
legal
prestat o
services.
muncă
In these
net mai
conditions,
mare decât
you
costul
are saying that
automobilului.
the work
Fapt care
exceeded the
prezumă
price
că
of
nu
the
ați
car.
avut timp să
This
prestați și
would
alte
mean that
servicii
you
juridice
did not have time
în
to
calitate de
offer
avocat
other legal
altor
services
persoane
as a
fizice
lawyer
sau
to
juridice.
other individuals
Apare întrebarea,
or
în toată
legal
această
persons.
perioadă,
The question is
dumneavoastră
whether
afirmați că nu ați
throughout this
restituit
period,
bani
well, you
costul
said that you did
automobilului, dar
not
ați
pay
prestat
money
servicii
for the
intelectuale.
car, but you offered the
Dar
intellectual
care era
services.
sursa de existență în
So
aceste
how
condiții?
would
Dacă
you
dumneavoastră nu încasați de la
live?
aceeași
What would you
companie
live off
alte
throughout
sume
this
de
period
bani?
if you did not receive any other amounts of money? This was not for covering for the car, but they were other payments for the lawyer's office, and the commission identified other payments that were made. You saw the income tax, for example, the activities related to opening and developing the hotel. This was something that I took care of, but this was not in the initial legal assistance contract. This is one aspect. And then we hired the persons that would take care of this activity, persons specialized in this area.
Are there any other questions by commission members? All right, Judge Aramă, would you like to say anything else before we conclude the hearing? Is there anything you've commented, obviously, earlier? Is there anything else you'd like to say?
Doar ca un cuvânt de încheiere.
Just like remark in the end, I am a bit embarrassed by certain declarations or how we discovered some situations after so many years, and I'm sorry that I did not fill in, or I didn't do some things correctly as per the law. And I maintain my declarations. What I declared to the Commission is the truth. I did not hide anything. There is no logic in hiding certain circumstances. Thank you very much for this exercise, and I hope that there will be an objective assessment. Thank you.
Well, that then brings us to the end of today's hearing. Judge Aramă, thank you again for your submissions and answers to the Commission's questions. After the hearing, the Commission will approve an evaluation decision stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 26. The Commission will strive to complete its decision and announce its conclusion as soon as possible. It generally seeks to do so within 1 month of a subject's public hearing. This hearing is now closed. Good afternoon to everyone.